More and more clients are coming to see me wanting prenuptial agreements. There was an important case in the Supreme Court in 2010 which set down some guidance about how prenuptial agreements are dealt with in this jurisdiction. What the case did not say is that prenuptial agreements are binding, come what may. But I'm going to talk to you a bit about what they did say. The factual matrix of the case is interesting. Katrin Radmacher, the glamorous German heiress, married a Frenchman, a banker, in London. Before the wedding, Katrin's father insisted that the couple sign a prenuptial agreement, as she had inherited wealth. The agreement was prepared by the family's German notary. Now, Mr. Granatino was French, so he wasn't fluent in German and certainly not enough to understand the agreement in full. The agreement didn't set out Mrs. Radmacher's true worth, and Mr. Granatino didn't get independent legal advice on it. The agreement was for separate property. What's mine is mine, what's yours is yours. After 8 years, the marriage ended and there were 2 children. The husband didn't want to be kept to the terms of the agreement and took the matter to court. The court, whilst not ignoring the prenuptial agreement completely, awarded the husband more, over £5.5 million. £2.5 million was to provide him with a house. The wife appealed and the case fought right up to the Supreme Court. And the Supreme Court lowered his award and actually said the £2.5 million for the house he could only have until the youngest child was 18, and then it was to go back to the wife. The court said that a prenuptial agreement freely entered into by the parties should be upheld unless in the prevailing circumstances at the time it would be unfair to hold the parties to the agreement. So what does that mean? Well, freely entered into at the time means there shouldn't be any duress. So you shouldn't be signing an agreement on the eve of the wedding because one party might later argue they felt they had to sign it, otherwise the wedding wouldn't have taken place, and might seek to overturn the agreement on that basis. The court also said that you can no longer argue later that you thought the agreement wouldn't be upheld in this jurisdiction. The court were making a strong message that from now on agreements would be upheld and that wouldn't be an excuse. And you should both have independent legal advice, which means that you both need to go and see separate solicitors in separate firms and negotiate the precise terms of the settlement. If you are the financially stronger party and your future spouse can't afford to go to a solicitor, if you want a prenuptial agreement, you're better off paying for them to get some independent legal advice, because that will make the agreement more watertight and therefore more worth it. Moving on to what the Supreme Court said about, in the circumstances, it being fair. As I often say to my clients, fairness is an elastic concept and different judges consider fairness differently. The agreement must therefore provide adequately for the financially weaker party. It must certainly have built in a review, because the Supreme Court said over time the agreement will be weaker in a long marriage if the agreement was just signed before the wedding and not reviewed. And there must be adequate provision for children. So if there are no children, the agreement must provide for a review if there are any, and if there are children already, it must provide sufficiently for those children's needs. Another important point the Supreme Court said was that if you know and understand the implications of signing a prenuptial agreement, but were indifferent about the other party setting out their assets fully and in detail, you will still be held to the terms of the agreement, and you won't be able to argue, I didn't know the extent of their wealth, and if I did, I wouldn't have signed this. When you go to see a family lawyer, they will take your detailed instructions about the terms of the prenuptial agreement and explain to you more about what it must contain. The trick to keeping your costs down is to talk about the agreement as much as possible with your future spouse before you go to see your family lawyer, so that your instructions to your respective lawyers mirror each other. People sometimes say to me, Lisa, prenuptial agreements aren't very romantic, are they? But an argument to that is, well, you wouldn't go on holiday without travel insurance. You're preparing for the worst case scenario. And the good things about prenups are that it brings certainty, and also it encourages a couple before a marriage to talk about money and their finances jointly and separate. In relationships, money is a real flashpoint for arguments. In my view, if you can have open and frank discussions about money and about your assets before the marriage, that stands you in good stead, and you'll learn more about the other person and perhaps go into the marriage with your eyes more open. A good way to negotiate and conclude a prenuptial agreement is using the collaborative process, where the couple and their lawyers sit around a table to discuss it, and the lawyers are there helping the couple together to reach a compromise agreement in both their interests. Finally, if you are watching this contemplating marriage, congratulations, and don't leave it too late in the day to go and instruct a family lawyer if you are considering having a prenuptial agreement.